Hi, I'm Neil Milton. I want to talk about inheritance when there is no will. Who gets what? So the rules as to who gets what are set out by statute in Ontario. That statute is called the Succession Law Reform Act. And there's a whole series of rules. But basically, they start with if you had a married spouse and no children, everything will go to the married spouse. If you had a married spouse and children, the married spouse gets the first $350,000. And then there's a method for sharing among the children and the spouse going forward. If you had a common law spouse, they get nothing under this regime. Also, if you were separated for 3 years or more from a married spouse, they get nothing from this regime. So important to recognize the difference between married and either separated or common law. Remembering this distribution scheme is all about the estate and doesn't deal with jointly owned houses and jointly owned bank accounts, doesn't deal with assets that pass by beneficiary designation. If there's no spouse, no children, then it goes to the parents. If there are no parents, it goes to the siblings. If there are no siblings, it goes to the aunts and uncles. So there's this whole tree. There's some wrinkles depending on, for instance, if it goes to the siblings, if one of your siblings is alive, but one of your siblings has passed away, it might be split between the two of them, but with half going to the children of the one who's passed away, for instance. So not necessarily what you intended or not necessarily ideal, but equally there is a method, there is a process for dealing with the administration of estates, even if there's no will. And it can be applied quite rigorously and distribute the estate. I hope that's helpful. If you have questions or concerns, send us an email. We'll get right back to you.